Good afternoon, everyone. Thank you so much for joining us today for Your Trust, Your Pet, and Your Legacy Estate Planning 101. I am Mia Dunn. I'm Director of Philanthropy for Pasadena Humane, and one of my responsibilities is our Plan Giving program. I am going to, after Bill's presentation, I'm going to speak a little bit about the benefits of naming Pasadena Humane in your estate plan, if that is something that you are considering doing, and how that can help the animals. And also, I'd like everybody to know that we will be sending out a recording of today's webinar in a couple of days so that you can have it for future reference if you have any questions. And we're also going to be putting up contact information for myself and also for our presenter, Bill. So I would like to now introduce our presenter for the day, William Hayes. Bill is originally from Chicago, and he moved to Los Angeles as a young boy. And his first dog was a brindle boxer named Duke, who was adopted from the family's local shelter. Bill is a graduate of the UCLA School of Law, where he served as senior editor of the UCLA Law Review. And among the many hats he has worn are as member, editor, and grader of the UCLA Moot Court Honors Program, the associate editor-in-chief of the National Law Journal, syndicated newspaper columnist writing about estate planning topics. He's also a contributing author to several books on estate planning. And of course, he's founder of the Hayes Law Firm in South Pasadena, where he handles estate and business planning. Bill is also currently a member of the American Academy of Estate Planning Attorneys and the Estate Planning Council of the San Gabriel Valley, among other groups. And outside of the field of law, Bill has tried his hand at comedy. He's studied stained glass design. He's traveled extensively. He plays the flute, and he has also practiced martial arts for 20 years, earning his black belt. Prior to founding the Hayes Law Firm, Bill was a lawyer in the film and music industry for many years. So now I would like to turn it over to Bill. Thank you very much.
Thank you, Mia. Thank you very much. Well, folks, we are here, of course, to talk about estate planning. Second. It seems that we're not, there we are. And you've already heard my resume from Mia, so I won't dwell on that. I can tell you that our firm has been cited by most of the major media as a source of information on estate planning. Our firm has been located for the last 22, 23 years in South Pasadena in the historic Behringer Studios building, which is located at the corner of Orange Grove and Mission Street in South Pasadena. I'm proud to say that we've received citations from a number of reputable sources citing us for our ability to do quality estate planning. Now, one of the things I've noticed over the many years that I've been doing estate planning is that people often forget to consider their pet companions in their estate planning. Of course, you think about the children and your family members and charities, but people don't seem to remember that their pets are as important to them as many other things are in their lives. So what we do when we do our estate planning, we have pet subtrusts that we create for our clients. Now, in a survey conducted by Kelton Research, 81% of people surveyed indicated that their pets were as important to them as their children. That may not be the case for you, but it is an indication that pets are important to us and should not be forgotten. You want to make sure that your pets are considered in your life. But only 9% of people who have done wills or trusts have done anything with regard to including their pets in their estate planning. And mind you, that's to be considered when you know that only 40% of the entire population has any planning at all. That means that pets are often left out of the consideration with regard to planning. Why are pet trusts important? Well, as I've indicated, when people pass away, they often don't have plans for their pets, those pets often will wind up in crowded shelters or on the streets. Sometimes people will just assume that family members or friends will take care of their pets, but that's a large assumption to make. And you really have to look at that very closely before you just assume that someone's going to take care of your pet. Certainly, you would hope that they would do it in the way that you have, but if not, you certainly don't want them putting the pet in harm's way in any way. Your pets depend on you. If you haven't provided for the care of your pets, who's going to care for them? There are different documents that have to be created to have an effective estate plan. The things that you may want to consider with regard to those documents are a power of attorney, which is a document that is meant to authorize someone to act on your behalf in the same way that you would act and at your direction, because you put those directions in the power of attorney. Or it may be that you have a will. A will is a document that is required to go through the court process before it can be implemented, the wishes can be implemented. And the other choice would be a revocable trust, often referred to as a living trust. With a revocable trust, you name someone to be in charge of your affairs if you should become disabled or die, and they have an obligation to honor the directions you put forth in that document. Now, with the powers of attorney, you will name someone who essentially steps into your shoes if you are disabled. Powers of attorney will only last during the duration of that disability. If you should become disabled, you want to make sure that you provide any documents that are necessary for the care of your pets and your estate in general to that person who's that you've named to care for you and to care for your assets and your pet. Your pet caregivers may be charged with doing more than just caring for the physical pet. They may also be authorized to use money to care for that pet, to maintain that pet's needs. So if you have a pet that has health issues or other particular problems, you certainly don't want to have that debt put onto the shoulders of the pet caregiver. You want to provide in your trust documents or will, or however you choose to do it, the amount of money that you are allocating for the care of that pet. And as I may have mentioned, powers of attorney terminate when a person dies. Okay, they're only good for the time that you're alive, and they are only meant to care for you while you're disabled. If you should recover, the power of attorney can terminate. And if you die, then the power of attorney goes away. A will is another possibility for handling estate planning. And with a will, pardon me, go back there. With a will, there's a drawback. The will must go through a court proceeding. It obligates you to go through a court proceeding. So if you have only a will, you must file that in court, and you must have a court oversee the provisions of that will, and it's quite a long-term process. A trust, on the other hand, is something that is internal. You will create that document, and you don't have to file it anywhere. You will have that document, and you will set forth what your wishes are with regard to your pet, how you want that pet cared for, what problems that pet may have. And if you are going to set aside a reserve of funds to care for the pet's needs, that can be indicated in that pet trust. Now, of course, you have a choice between whether you want to use a will or a trust. In either case, you name someone to be in charge of that document. If you have a will, the person would be titled the executor of that will. And if you have a trust, that person's title would be trustee. In my estimation, a trust is always better than a will when planning for your pet. One of the big problems with a will is that it can take a long time to execute. In probate court these days, it averages for even the simplest of the estates about a year before the estate can be closed out under a will. And it can take considerably more than a year. I mean, I've had estates where I've been the third attorney on an estate, and it took 28 years for that estate to close. Now, of course, that's not going to happen in most instances, but it gives you an indication that there are bumps along the road whenever you go through probate court. And if you can avoid the court system, you certainly want to do that. On the other hand, if you have a trust, that is something that you can implement immediately. The provisions in the trust will be, must be followed as you've indicated. So if your trust indicates that upon my death, this pet is to go to this person, and I've set this amount of money aside for the care of my pet, and these are the expectations I have for how the pet is to be cared for, well, that can be done without any court, without having filed the document anywhere, because you don't file trust typically with any entity. You don't have to file it with the county or with the court or anything like that. It's an internal private document. Unfortunately, in California, pets are just considered personal property. Though you have a relationship with your pet, the state of California considers them essentially the same as your car. It's property. So whether you have a will or whether you have a trust, the pet cannot be the actual heir of that asset. It has to go to someone who can, the money, if you, for instance, if you're leaving money, it has to go to someone for the purpose of taking care of that pet. And again, you will set forth how that money is to be used. When you leave a pet upon your passing, you don't want the care of that pet to be left to chance and to have somebody try to figure out whatever problems the pet may have. You want to clarify that in your estate documents. And it may be, if you are deciding to leave money aside for the care of the pet, that you take into consideration the following things, such as the feeding habits of the pet. It may be that certain types of food are necessary for the pet. Or you want to specify what the veterinary information is for the pet and what the medical history is there. If there are medical conditions that the pet is dealing with, you clearly want to make sure that the new pet companion has a clear understanding as to what those are. And then there are things that are, more maybe not as important to us, but certainly to the pet. You'll want to maybe indicate the favorite toys and activities and whatever special quirks there are for the pet, so that the new person taking care of your pet companion has an understanding and will not be surprised by these things or irritated by these quirks, for instance, that a pet may have. Now, if you have been maintaining a social media presence for your pet, you will at least want to let the new pet caregiver know about that and give that person access. It's very important that you not assume that someone will automatically care for your pet. I've often had people come in who just say to me, oh, my daughter's going to take care of the pet. Or my friend is going to take care of the pet. And that's quite an assumption to make. I mean, because people have their own lives and their own interests, and their interests may not be in line with yours as it relates to your pet. So when you decide who your pet's caregivers will be, it's very important that you have a conversation with them about the pet and your expectations if you should name them as the caregiver for the pet. I know that it is often difficult to think about who you can trust with money that you may leave for the care of the pet. We all have numerous acquaintances, but there are only so many people that we truly have faith in, trust in to do the right thing. So if you're concerned about the person that you designated as your pet caregiver, and there's the possibility that once the money is given for the care of that pet, that person's priorities may be given a higher rung on the ladder than the care of your pet, you may want to set up your trust in such a way that the money is given out on an as-needed basis by the trustee of your trust. So if there's a need for medical care, then you may want the trustee to pay those medical bills. Or if you feel somewhat confident about who your pet caregiver is, you may want to just have a monthly allowance or a yearly allowance if you have that degree of confidence. But if at all you have concerns about whether the right thing is going to be done, it's important that you consider naming someone who can monitor the expenditures for the pet. And that can be the trustee of the trust. It can be an outside person that you designate who checks in periodically to make sure that those things are being taken care of for the pet. And of course, if there are any monies remaining in the trust, once your pet passes, you can stipulate that the balance be given to a charity of your choice. But we, of course, would ask that you consider Pasadena Humane as the beneficiary of your estate plan, because as you know, Pasadena Humane has been taking care of pets like yours for many, many years, and certainly deserve to be supported. Now, we're going to switch gears here, and we're going to talk about estate planning in general. And the pet trust is just one of the parts of the estate plan. So it's important that if you have an estate plan, or if you're thinking about doing some estate planning, that you have a clear picture on what that should look like for you. And we don't have to speculate about whether it's an important time to do estate planning, because these are very difficult times in our country and throughout the world. There's a certain level of anxiety, I'm sure, that we all suffer from because of the problems that seem to present themselves daily. Over 15 million lawsuits are filed in our country every year, and of course that compounds year after year. So it's no wonder that our courts are clogged with litigation, and we are litigious. Well, not over, but generally 750 to 1 million people have to file bankruptcy every year. In the year 2022, the national average cost for a one-year stay in a nursing home is $112,296. That's the average. So if you want someplace that's better than average, you're going to pay more. 60 million Americans give aid and attendance to family members and friends. And there are countless lawsuits filed every year as a result of poorly drafted wills and trusts. And I used to always joke about America used to have the highest divorce rate in the world, but now we're just number 3, following Belarus and the Maldives Islands. So we can't win them all, right? So, it's also important for you to know, and I think I've mentioned it, but it's 46% of all adults do not have an estate plan in place. So you can, of course, choose to be part of that 46%, or you can make sure that you've put a plan in place that is meant not only to protect you, because it will protect you during your life if you have it drafted properly, but it is also meant to take care of the people that you care about and your assets. You do an estate plan because you can't take it with you, and you want to create a legacy, and you can do that by having planned for everything that you've created in your life to pass it on to whomever you wish to benefit, whether that be family members, friends, or your favorite cause or charity. 46% of all people don't have a will or a trust. the number of Americans is up with people who don't have a will versus what they had in the year 2016. Almost a third of Americans aren't sure if their parents have a will. Over a third of Americans are clueless as to what's in their parents' will. People become quite protective as we get older, and sometimes people are not sure about the motives of people who ask about their estate planning. I mean, you know, there's sometimes the sense that, are you planning for me to die so you can grab my assets? Well, that's not generally the case, I wouldn't believe. I mean, certainly it is in some instances, but most times I think it's just wanting to know, what should I do? You know, I need to know where things are so that I'm not running around trying to figure these things out and missing things. So it's important that you have conversations with those who are meant to take care of your affairs if you should become disabled or upon your eventual death. 26.8% of all people between the ages of 18 and 34 have estate planning documents versus 22.5% of those aged 35 to 54. So that's pretty bad when you consider that the older you get, the fewer people who have documents in place goes down. This period is going to be a big transition of money from one generation to the next. $59 trillion is expected to be transferred from 94 million estates up by the year 2061. 7.6% of Americans don't know how to get a living will or trust. They're not sure what it even means. They assume that if you just buy a form, that's going to be sufficient. Well, that is not truly the case. And 58% of Americans without a will haven't started thinking about it or making a plan to do so. And let's not forget the real dangers of the coronavirus and other global health issues. I just read this morning a report from the CDC that they are pretty much stating that the virus will never go away, and there will always be permutations of the virus that we'll have to deal with as we go forward in the future, which I would guess may mean that we are now saddled with a life of having to consider the next booster shot as we go through life. But it's still a real danger. This morning, we're going to, this afternoon now, we're going to profile a typical couple, Bill and Mary Jones. Pasadena couple, they have an estate worth about $700,000, which includes their home. Now, this will apply to you, this discussion will apply to you whether you are single, widowed, or divorced. And you'll be able to see the very few instances in which it does not apply. Bill and Mary have 2 children. They have Susan, who is pretty much the golden child in the family. She's always going to do the right thing. Mom and dad know they can rely on her. And then there's John, who's the problem child. And John has been, though loved, he has been somewhat of a burden for Bill and Mary throughout his life. Bill and Mary have all types of planning options. One, they could spend every dollar that they have. I always make this joke about a bumper sticker I once saw in driving through the Hollywood area that said, "No dime left behind." Well, that's certainly a planning option, maybe not a good one. You can die intestate. To die intestate means you've done no planning. To die testate means that you've planned. Sometimes people will come to me and say, you know, Bill, I think I want to just put my daughter or my son's name on my accounts and my house, and that's my plan. And my response to that is always the same. I would think long and hard about that if I were you. And the reason that I say that is that if you put your child's name on your assets, every problem that child may encounter then becomes a problem for your assets. So you really want to think about that long and hard. And in addition to that, if you put the child's name on your house, what you are doing is creating a capital gains tax problem for that child that they don't really have to have. Because if you put their names on the house, they will have to pay capital gains tax on the appreciation which occurs for that property from the time that you initially bought the property. So maybe you don't want to do that. If you just leave it to them by way of a trust or will, they receive the property at a new at the current value. And if they were to sell it the next day, they won't have to pay any capital gains tax. Sometimes people will say to me, I have a simple estate. And I always ask the question, well, what's a simple estate mean for you? And they will say that I have a house and I have a car and I have bank accounts and I have a retirement plan. And my answer is then you are basically, you have the same assets as about 95% of my clients. That's what we all have. Now, it may differ as to the amount of those assets, the value of those assets, but we pretty much all have the same assets. And if you have a will, remember, what a will does is require that you go through the court process in order to close out that estate. Unlike with a trust where you can just close it out internally and never have to deal with the court system and all the tremendous costs that come with court process wills. Many times people will consider just getting a form, a bare bones living trust, as I refer to it. And of course you can do that. In fact, you can always go on the internet to get that. There are always forms there. But the old adage about you get what you pay for couldn't apply more than here with this situation, because those are just forms meant to take care of everybody that is who buys that form. And that's not the way life is. Your assets and your affairs are going to be considerably different from the person next to you. So we always suggest that you create a complete family wealth trust, and we'll talk about that a bit more. So in our example with Bill and Mary, Bill has a stroke. Now, this, of course, was not something that was anticipated. Bill and Mary have a will, and they did that estate planning, and they felt that that was adequate estate planning to cover whatever it is they needed. Because, of course, they went to an attorney, maybe who does work in a number of different areas, and the attorney says, sure, I'll do a will for you. But the attorney may not even know that what that will actually does and its limitations. When you have a will, it does not take into consideration some of the problems that people encounter as they grow older, such as medical bills and long-term care expenses. Over 66% of all bankruptcies are caused by medical bills. And what's even more troubling is that 75% of those medical bankruptcy filers had health insurance, and still they had to file for bankruptcy because of the extreme cost. Now, there's a difference between health insurance and long-term care insurance. Now, there's a reason that there is long-term care insurance, because long-term care insurance is meant to take care of those medical expenses which are ongoing, chronic issues. Health insurance is meant to take care of doctor's visits and hospital visits. So don't expect Kaiser and Blue Cross to take care of your long-term care medical expenses. Medical expenses that are long-term come in various forms. In terms of the expense, it could be that you have to wind up paying for in-home care or adult daycare or assisted living or a stay in a nursing home. Genworth Insurance, which is kind of the leader in the long-term care insurance industry, does an annual survey. And in 2020, their survey indicated the cost that you see on the screen for the average cost in the state of California. And these are costs for Los Angeles County. So obviously, if you don't have long-term care insurance and you have to pay these expenses from your pocket, it's going to be quite a problem for you. And remember that these costs increase on average about 3 to 4% per year. So how do you pay for long-term care expenses? Well, One, if you don't have long-term care insurance, you use your own money until you are unable to pay for your long-term care needs. If you have long-term care insurance and you can qualify for it and pay for it, that's a great thing. I always recommend that people look to that first if they can. Now, of course, most people do not have long-term care insurance. Medicare, I know, is something that we generally think of as something that will take care of these kinds of expenses, and on a limited basis, it does. But in most instances, Medicare will only take care of 100 days of care, and after 100 days, the burden is on you personally. If you're a veteran and you served at least one day during wartime, the VA will take care of your medical expenses. But if you don't fall into any of those other categories, if you don't have the money to pay for your own long-term care out of your pocket, and if you don't have long-term care insurance, and you weren't a veteran who served during wartime, you are only left with one other option, and that is Medicaid, which is known in the state of California as Medi-Cal. And that's a joint program of the federal and state governments to provide long-term care medical coverage. But of course, you must qualify to receive that type of coverage. The way in which you qualify is to first spend all of your own money and then not have any more money in order for you to qualify. So in the case of Bill, let's look at his example. Bill becomes disabled as a result of his stroke. He's unable to make decisions anymore or communicate effectively. That presents problems for his wife, Mary, because she still has to deal with all the expenses of their household. How is she going to do that? And now she has the added burden of having to take care of Bill's rehabilitation costs. What is she to do? Well, of course, if you're in that predicament, you start looking to the largest assets that you have. And in Bill and Mary's case, they have an IRA. And this is an IRA that Bill obtained through his job. And he has Mary as a beneficiary of that IRA. Now, Mary decides that she's going to cash in the IRA. So she goes to the administrator of the IRA program and says, Bill and I have an IRA and I need to cash that IRA out so that I can pay for our cost of care and our household for, at this point in time, because we don't have any other way to do that. And then Mary, of course, gets a shock of her life. The IRA administrator tells her, no, you can't access this asset. You cannot take the money out of the IRA. And the reason is because this is Bill's IRA. And Bill would have to sign for the release of those funds. But since Bill is disabled and unable to do so, Mary cannot access that IRA account. So Mary then goes to the second asset, the biggest asset that they have, and that's their home. She and Bill have been in the home for over 30 years. It's paid off. So she goes to a realtor and says, listen, I'm in financial jeopardy here and I need to sell my home. I want you to sell the house. And the realtor has to tell Mary, Mrs. Jones, I can't do that. And of course, Mary is again shocked. She says, why can't you do that? This is my home. Well, the realtor has to tell Mary that both she and Bill have to sign for the sale of that property since it's held in joint tenancy. So Mary cannot sell the home, nor can she access the IRA, her two biggest assets, and she has no way in which to take care of the household affairs and Bill's rehabilitation. What that means is that Mary will be forced to petition the court to be appointed as Bill's conservator. Conservatorship is a process in the probate court which is meant to deal with the affairs of a person who is mentally or physically disabled. And we in our office refer to that as living probate. When you are in a conservatorship, it is really a terrible place to be. I've witnessed many conservatorship hearings over the years, and I can tell you it's a very humiliating process. It's extremely expensive. The court is in control of your life, and by its very nature, it is a long-term process. You don't wind up in a conservatorship that's finished in 6 months. It goes on for years. And what I see is that in most instances, people come out the other end of that funnel with no money. Can you imagine having 2 and sometimes 3 attorneys charging against your assets on an hourly basis? And if I didn't make it clear, all the costs of a conservatorship come out of your assets. And that's what Mary's now faced with. But going through that conservatorship will allow her to finally access those assets, but the cost of doing so is extremely expensive. Now, ultimately, Bill dies, and again, since they have a will, that's going to be the governing document for how the assets in that estate are processed. When you have a will, it does not avoid probate, it guarantees probate. That's the whole purpose of having a will, to have it read by a court and processed in that way by the court system. When you are in the death probate process, its purpose is to resolve disputes between parties, pay creditors, make sure that all the assets are marshaled, and to change title on those assets and ultimately distribute those assets to the named creditors and beneficiaries. Probate is very expensive. When you have a probate estate, the fees which are paid to an attorney and to whomever is named as the administrator are very expensive, because it's a percentage of the gross value of the assets which are being probated. So that means that if you have a house that's worth $500,000, but you only have $100,000 in equity in that house, the fees payable to the attorney and the administrator are based on the $500,000, which means doesn't care what equity you have in that house, the fees are going to be pretty exorbitant. And the attorney and the administrator are paid the same amount in terms of the fees, and they're set by state law. So you want to avoid probate at all costs, because you're going to incur court fees and publication and bond fees. It's time consuming. As I said before, minimally these days, it's taken about a year to get it done. It's open to the public. Anybody who wants to know about what is in your estate only has to go down to the court, first floor of the courthouse, to their file room, and pull the file, and you'll be able to find out what that person had in the way of assets and who is going to get those assets and approximately when. That's why sometimes California, Los Angeles, that is often referred to as the scam capital of the country, because anybody with ill intent only has to go down to the court and pull files, and there's this open market of potential victims that they can go after. If you have assets in more than one state, you have to have separate probates occur in each state in which you have assets. Now, let's say that Mary lives another 10 years after Bill has passed, but ultimately she is afflicted with Alzheimer's. So she goes into a nursing home. And about half of the elderly do wind up in nursing homes before dying. Mary's unable to handle her affairs. Fortunately, she did some planning after Bill's death, and her planning consisted of preparing a power of attorney. Susan finds that power of attorney. She is able to see that document and assume that she's now able to do whatever she needs to do for her mom, because she is named as the agent under that power of attorney. So Susan consults an elder law attorney. That is something that we practice in our firm. It's a specialized form of estate planning. And what elder law is meant to do is to preserve the assets of people as they age and to protect them from the ravages of long-term care medical expenses that come with aging. So, and that's just, of course, one of the things that elder law is about, but that's a primary purpose of elder law. So Susan consults an elder law attorney, and she says to Susan, you know, we can protect most of your mom's assets if, and the if is, if there is adequate language, appropriate language in the power of attorney, which will enable us to do Medicaid planning, which would allow for us to transfer assets out of your mom's name so that she can then use Medicaid to pay for all of these long-term care expenses, which are otherwise going to drive her into bankruptcy. Well, the power of attorney which Mary did obtain was just a form document, which did not include that power. So as a result, Susan is stymied. She can't do anything. She can't move assets about and do the type of the strategic planning that one can do to protect the assets and have those costs covered by Medicaid, also known as Medi-Cal. I have found over the years that the reason that most estate plans fail is one, that people use canned documents, forms, assuming that one size fits all. And, you know, understandably, I see why people would do that if they don't have information otherwise. Plans fail because they have done nothing to take care of what is going to happen to most of us. The US Department of Health says that 7 out of 10 people over the age of 65 will wind up with long-term care medical expenses. So if you haven't planned for how you're going to take care of that, and knowing that those long-term care expenses are likely to be a probability rather than a possibility, like 7 out of 10, you haven't really fully planned. If your documents don't have a plan in them for medical expenses like that, you don't have an adequate plan. Plans also fail because people will go sometimes to programs that say, oh, listen, we'll do your planning for this minimal amount of money. And really what that is about is just giving you some forms, and then they leave you to do the funding of those estate plans, which means that you have to do all the titling of the documents and whatnot. They give you the forms to do it, but of course you have to figure that out. And as a result, you can imagine that most people are left confused by this, and you know, a confused mind really winds up doing nothing, and you put it out of your mind. So if you don't fund your trust, and by funding it, I mean transferring the title to that asset into the name of the trust, then you don't have a trust which has been funded with your assets, and the trust therefore has no authority over those assets. Trusts also fail because there's no remarriage protection in them. What I mean by that is that Bill has died. What happens if Susan remarries? I mean, with Mary remarries, where do the assets wind up going? And there's insufficient protection in the plan for heirs. There are different ways that you can set up the plan to make sure that the assets that you leave to beneficiaries are left to them in ways that you know will best benefit that person. So on the one hand, we have Bill and Mary's daughter, Susan, who is a responsible person, and they may want to leave assets to her in one way, but they know that John is irresponsible, and they certainly don't want to leave those assets directly to John because it will just be a waste of those assets. Another reason that plans fail is that after you have had your plan created, there is nobody keeping you up to date about changes which occur every year with regard to estate planning documents. If you are not kept aware of the changes which can occur with regard to your documents, you are essentially left in the dark. You don't know whether your documents will fully work in the way that you want. So what is an estate plan and how does it work? An estate plan will consist of a number of documents. There will be The living trust, also we refer to as a revocable trust, which means that you can revoke it at any time, you can change it at any time. Then there's a document that accompanies that, which is called a pour over will. And it's called a pour over will because if you leave an asset out of the trust, you forget to title it in the name of the trust, your representative can go into court and say it was the intention of Mrs. Jones that this asset be a part of her trust, and we'd like to pour it over into the trust. When we do estate plans, we also do powers of attorney. And there, if you're a married couple, there will be a power of attorney of two types, financial and health, for each spouse. And of course, for an individual, it would be just the power of attorney for health and finance for that person. There are a number of other documents that we include with our powers of, with our estate plans as well. But it's meant to govern your documents upon your becoming disabled, and you will set out the plan of action as to what you want done if you should become disabled, and who is going to make sure that is done, and who the person that you have the greatest confidence in. And if you die, of course, the distribution will already be laid out in the way that you know will work best in terms of preserving your legacy and benefiting those that you want to benefit. While you are disabled, the powers of attorney are the documents which will allow your representative to deal with assets and make sure that bills are paid in the same way that you would. So the fact that you are disabled and unable to take care of your own affairs generally doesn't give much sympathy from creditors. I mean, if you're not paying your utility bills or your mortgage, they really don't care. So if you don't have anybody who is authorized to do this for you, you are left in a position where you might find yourself being subjected to a conservatorship. So if you're a single person, it's certainly important that you have somebody named. And of course, it's also important for you if you're married, but particularly if you're single. So let's give Bill and Mary a quick do-over, and this time let's assume that they have done proper trust planning. They don't have a will in this case. They're going to create a trust. And Bill and Mary, as couples do, Bill is now retiring, and he's got plans for what he's going to do, start that exercise program that he's been threatening to start for the last 30 years. And this time he means it. They're going to plan vacations, plan retirements, maybe even look into some long-term care planning. This time, Bill has that stroke again under this scenario. You have to remember that estate plans are not commodities. Estate plans differ depending on your circumstance. It is not like a bag of sugar, which of course, if you go to one store, you expect a bag of sugar to be the same as the next store, and the same for buying a Ford or a Chevrolet. Those things are standardized. Estate plans are not. Estate plans should be customized. Mary immediately controls all assets without court involvement when there is a trust in place. If Bill becomes disabled, the trust terms provide that Mary is able to make documents on her own. She is able to make decisions on her own. She will not need the involvement of the IRA administrator or have to go hat in hand to a real estate broker begging to sell her own home. She will have that authority already in place. Now, after Bill dies, Bill and Mary have a neighbor, Ralph, who's been their next door neighbor for 30 years, and his wife who's passed also. So perhaps he decides that, you know, Mary's a very attractive lady, and maybe he starts to make efforts in that direction to let her know that he's interested. But Ralph's wife died, and they went through a long period where all of their assets were dissipated because they had to take care of her care. And he doesn't have anything left. So we have to, of course, consider what are Ralph's motives. If he knows that Mary has assets, what are his motives for wanting to marry her? Is it for love or is it for money? Well, when we do estate planning, in our estate plannings, we have prenuptial language in the plan. And what that is meant to do is that if Mary should remarry, if she were to marry Ralph, there will be language in the trust that obligates Mary to observe the terms of the trust, which provide that she cannot commingle the assets that she and Bill accumulated over their marriage time with Ralph. What that does, of course, also is to protect Bill and Mary's children, Susan and John, because what we have seen many times is that people, when they marry after the death of a spouse, they just start to commingle assets. And what happens when that surviving spouse, who's now remarried, dies? Where do you think those assets wind up? They wind up with that new person. And certainly that was not their intent, but what it does in effect is to disinherit Susan and John. So this time around with the trust in place, Mary gets Alzheimer's, but there won't be the same problem for her with regard to managing her affairs. She will have already have named Susan, her responsible daughter, to be the trustee of the trust. This time around, there won't be any need for a conservatorship proceeding because in the trust documents, Bill and Mary will have already named who their legal caregivers will be. So you'll avoid the costs and delays and humiliation that come with conservatorship proceedings. So we have the trust in place. The question is now, will Bill and Mary's estates go into probate? And of course, since probate is meant to take care of the affairs of a person when they die, well, Bill and Mary don't have that issue because their assets are titled in the name of a trust, which never dies. So they won't have to deal with probate at all. So they avoid all of the court costs and the court process and the public exposure and multiple probates in different states and so forth. Avoid it altogether and all the expense that is entailed with that. When we do our estate plans, we know that it's important for Bill and Mary's wisdom and life experiences to be maintained as well. It's keeping the family history is something that is often overlooked when people do their estate plans. They don't really give it much thought. It's not that they don't find it important, they just don't give it much thought. Well, our estate plans incorporate that family history into the estate planning. In my estimation, ultimately, having that family story preserved is more important than the money that you leave to the beneficiaries, because that is a gift that will keep on giving. It will be something that will benefit your grandchildren and great-grandchildren and your extended family to know what the family's history is, and only you can give that gift. When you do a well-prepared estate plan, there are a number of types of sub-trusts that one can create under the umbrella of your living trust. So there might be sub-trusts to deal with remarriage, as I indicated, to prevent assets being distributed outside of the family line, or divorce protection sub-trusts for children to make sure that their assets don't wind up the subject of a divorce and having some son-in-law or daughter-in-law laying claim to those assets. And there are retirement preservation sub-trusts for your retirement benefits and annuities and IRAs and their grandchildren's sub-trusts. And there are a number of different ways that we can provide for the particular needs of your family that certainly are not taken care of by way of a form trust. As I've indicated, we practice elder law here, and I emphasize that because not all trusts are equal. Most trusts will not deal with long-term care medical expenses. So even though you have expectations of how your golden years will be, well, those expectations can quickly be upended if you haven't put a plan in place for what will happen if you have long-term care medical conditions that render you unable to act and therefore incur a lot of expenses for the estate. So the question for you is exactly when do you intend to create a plan? It's not, we're in the middle of a pandemic still, and I guess it's not going to go away. It's not as bad as it was, but you have to at some point stop trying to time the market, and this is the kind of thing you need to really get done. So life starts when you really have your plan in place. It creates a sense of security for you, for what you're doing for the people that you care about. It creates a legacy for you, and it kind of puts a point on clarifying that yours was a life worth living. So I think at this point, I want to turn it over to Mia.
Thank you so much, Bill. Wow, as always, thank you for a very informative, very detailed presentation on what is definitely a very important topic. And I hope everyone who's here found it very helpful. We're going to open it up to questions in just a moment, but first I wanted to speak to the topic of leaving Pasadena Humane or naming Pasadena Humane as a beneficiary of your estate plan. There's different ways that you can do that. You can include us as a beneficiary in your overall will or trust, or you can name us as a beneficiary of a particular vehicle, such as a life insurance policy or an IRA 401k or a charitable gift annuity or another account. You don't have to include us in your overall estate plan if you don't want to, but these are the options. And you can also leave a gift of real estate. We do have several donors who have indicated in their plans that we will be receiving their house. And then we also recently started taking donations of cryptocurrency. And so that is another way that you can leave a planned gift for us. And I would be really happy to talk to you in person or on the phone or even via Zoom if this is something that you're thinking of and that you would like to do to help the animals. I'd be more than happy to talk to you about it. No minimum amount is required, no minimum percentage. It's all up to you. But if you do take this step, which we hope you do, because you will be helping animals for years and years to come, is you will become a member of our 1903 Society of Planned Giving Donors, and 1903 is the year that we were founded. And benefits of joining are recognition in our annual report, invitations to events, you get a discount in our shelter shop, and also our Pet Guardianship Program. Now, we always encourage people to name a friend or relative or trustee to take care of any pets that they may leave behind. But we realize that not everybody has a network that they can rely on to do this. So in that case, Pasadena Humane can step in to care for your animals and rehome them. And again, that comes as a benefit of being a member of our 1903 Society. And so that's a lot of information to chew on, but as I said, I am available. You should all have my email and my other contact information. Always welcome to contact me if you want to explore this further. So now, and then I also believe a survey is going to be sent out following this presentation. We would really appreciate your thoughts on today's webinar. And with that, I will open it up to questions. and you can put them in the chat.
Okay, I think there's a question from Ms. Wong. Hi, Ms. Wong. You're muted.
If you're having trouble with your audio, you can also pose your question in the chat box. Should be at the bottom of the screen.
Okay, yeah, she's muted, so I don't know what's. Ms. Wong, while you're trying to get that handled, I will move to the next question, but we'll come back to you. It's Naki Margolis.
Hi, have I unmuted?
Yes, you have.
Okay, great. Yeah, I just had a question. What if you already have a living trust prepared by another attorney, but you want to update? It's been a few years.
Yeah, well, Ms. Margolis, it depends on what you need to update. There are two forms of updating. One would be to amend the provisions. So if there are minor changes that need to be made to the trust, and by minor, I mean if you wanted to change who the trustees were or the beneficiaries were, or an asset as to where that asset goes, those can generally be done by way of an amendment. But if you are looking to do wholesale changes, that's called a restatement. And you can have those done as well.
Okay. And would you be able to take a look at it and see if it looks like it's still up to date in terms of requirements?
The way that we handle that is that we have a list of questions that we will go through to determine what is important to you. You certainly wouldn't want to have us go through your trust line by line, because that just becomes too expensive, and I wouldn't ask anybody to do that. If you want to talk to us about that, what we'll do is go through those questions, and generally that works for most people in determining whether they want to amend their documents or change their trust altogether.
Okay.
Mm-hmm.
And is there contact information for your firm? I forgot to write it down.
Yes, our phone number is 626-403-2292.
Thank you.
Yeah, and our website is losangelostrustlaw.com.
Yeah, Bill, I think if you switch to the next slide, it should pop up our contact.
Oh, okay.
Yeah.
Okay, well, there it is. That's our contact information. Thank you, Ms. Margolis. Okay, I've gone to, is Ms. Wong, are you there?
Hi, yes, sorry, that was a mistake that I rose my hand, but this has been really informative, so thank you so much.
Well, thank you. Thank you very much for attending. Okay, there's someone from the area code 909, but there's no name. Don't know if they're still there or not.
Yeah, hi, Amanda. I see your question. Yes, we will be sending a link to a recording of the webinar in the next couple of days.
Amanda was not the 909 caller?
I'm sure. I don't know. I just saw her name. I didn't see
I see. Okay. All right. Okay. I guess so. The 909 caller, I can't access. So I'm going to Melissa Cohen. That's a very familiar name. Let's see. Melissa?
Can you hear me?
Yes.
Yes, I think it's very familiar. Yours is familiar too, and I hope to be giving you a call. But I
Hi,
don't have
Melissa. I know who you are.
Yeah, you do. I don't have any specific. I have a. I don't know. I mean, everybody's case is different, so I would have to ask you specific questions.
Sure, of course. Hey, look forward to talking to you, Melissa. It's been many years.
I guess one question I could have that everybody might relate to is I have several pets and I don't have anybody in particular who I think would be interested in taking care of them. And especially like most of my friends are my age, so they're not getting any younger. And I don't know any young people. So what do you do if you have pets, you can afford to leave money for their care, but you don't have a person?
I think that's a question that I'll turn over to Mia. She might be able to answer that.
Sure. Hi, Melissa. Yeah, well, as I mentioned previously, if you name Pasadena Humane in your estate plan in any capacity, whether it's to receive a specific gift, meaning the money that you set aside for the care of your animals, or any other way you would like to name us in your plans, that makes you a member of our 1903 Society of Plan Giving Donors. And one of the benefits of that society is our Pet Guardianship Program. So if you, as you said, you don't have anybody that you can rely on to care for your pets, if they outlive you, then at that point, Pasadena Humane can step in and care for your pets and rehome them. There would just need to be instructions in your plan that your trustee would have to contact us just to let us know. And if this is something that you would like to do, I can send you a Pet Guardianship Form. And what that is, it's several pages and it asks questions about your pets. And it's not mandatory to fill out, but when you do fill it out, it gives our staff a better idea of your pet, its personality, its health, health status, and a lot of other information, and it just helps us find the best home for your pet. So the slide that's up there now has my contact information, and I know that you've emailed me a couple times, so feel free to we can get in touch later if this is something that you want to explore, and I'd be very happy to help you.
Okay, but when people say that, and I've had other people talk to me about that, I would say that the pets that I have now are probably not going to be the pets that I have when, like, unless I die very soon, I will have a whole different set of pets because I adopt older pets and most of them are going to die soon. So how do you just provide for pets, just the unnamed pets?
Well, you would do that, Melissa, by just basically saying that, putting in a provision in your documents that whatever pets are surviving at the time of your death.
Mm-hmm.
Okay.
Yeah, and certainly you can update if you get new pets. Just can stay in contact with me, and you can just update information. Any information that you want to give us, you can update that at any time. But what Bill said, I think would cover, whatever pets you have at the time.
Okay, Mia, and is there a minimum donation for?
Not at all. Not at all. It's up to you. It's up to you how you want to include us.
Okay. In order to be a member of that 1903 society?
Yeah. And it may be a case of, say you've got 2 dogs and you want to leave money for their care, and say, I would like to leave $10,000 for their care. And then just for figures, and then just, and have the Pasadena Humane Society care for any that I may leave behind. You can. I'm not sure of the exact wording, as I'm not an attorney, but you can. It's something along those lines.
Okay, that's kind of what I'm looking for.
Yeah.
Like any animals I have, and it's not, the money isn't an issue so much as I know a lot of rescues, but I don't know if they'll be around when I die. So the fact that you're established is a good thing.
Yeah, we're celebrating our 120th anniversary next year, so I think we'll be around for a little bit.
Okay, yeah, that sounds good.
I think you can work with Bill and get the wording just right. That will make that happen.
Okay, great.
Bye, Melissa.
Bye.
Okay, I'm moving on to Brenda Cano. Brenda?
I didn't actually raise my hand or have a question.
Oh,
If I hit something I shouldn't have.
no
But
problem.
for the program, because I learned a lot from it, and I'm planning to review it when I get the link to the recording.
Okay,
Oh, I do have a question though.
sure.
Do you have any offices in the San Fernando Valley?
No, I don't. No.
Okay. All right. Thank you.
Okay. Let's see. And I think you already answered Amanda Lynn, did you not?
Yes.
Okay.
There is another question from Sherry Leon. When can we get an appointment for a children's living trust? I think that's what.
Well, you can always call the office and speak to our Amanda, and she'll schedule a call. Okay. Okay, and now Camille Dudley. Ms. Dudley? Okay, I guess she stepped away. And now I'm at John Marinkovich. Mr. Marinkovich? Okay, nothing there.
If you want to ask a question, please check your mute button just to make sure you're not on mute, if anyone's out there, or you can just type it into the chat.
I'm now moving to Kathy Hall. Ms. Hall, are you there? I don't know if there's something not connecting me or whether people have just left the...
It's possible, but
Yeah.
if anyone out there who's still with us that has a question, you can either unmute and ask it, or just simply type it into the chat function at the bottom of your screen.
Okay, and I just clicked for Lynn Peckham. Okay, Ms. Peckham. All right, so what I'll do, I see that there are a number of people who have indicated an interest in the chat. Let's see. Let's see. Okay. Pardon me. Okay, I think that may be everyone.
Yeah. Okay, well, again, I want to thank everybody for spending time with us today on this topic. And again, if there's anything that we haven't answered, or if you want to want some more information, you feel free to contact either Bill for his expertise, or you can contact me if you are interested in becoming part of our 1903 Society. And again, doing this will help the homeless and abandoned animals in our community for a long, long time. So thank you very much for your consideration. And everybody have a wonderful day.
Thank you. Bye, everyone.
Thanks again, Bill.
Oh, you're welcome, Mia. Take care.
Bye-bye.
Bye.